Okay, I think we can probably get started. Thanks again, everybody, for taking time out of their day to join us today. We've had lots of questions on this topic, so we thought we would do another webinar. And I think there's some people in the group that I haven't met before. I'm Greta with Lighthouse, Greta Gay. Also here with Bruce Cross. He is a director at the Rose Law Firm, along with the co-owner of Lighthouse. So, like I said, we will try to get to all your questions in the chat. If you'll put those or in the Q&A. And if we don't, I'll get back with you after the webinar's ended. And then we're also recording and we'll be sending out the links as well. Before we get started, though, there is some new information that just came out late yesterday afternoon, I believe, in the Wall Street Journal. There is a newly appointed director of the OFCCP, and she announced that the agency will review federal contractor affirmative action plans previously submitted to the agency for evidence of discriminatory employment practices. So if we had an open audit and then it was put on hold, or if we are under a conciliation agreement, we might have to answer more questions or at some point provide those conciliation reports sometime in the future. So as we said, when all this, in end of January, when the new EO came out, if you did have a conciliation agreement, we did put out some guidance saying, don't quit what you're doing. We still might have to submit those reports at another time. So just be aware that that came out, and we'll be watching to see what happens with that. And with that, I'm going to turn it over to Bruce.
Okay, thanks, Greta. Hopefully everybody can hear me. If there's any problems hearing our presentation today, please note it in the chat. Otherwise, as Greta said earlier, if there are questions that you have as we go through, please go ahead and add them to the chat, and we will attempt to try to answer them to the extent we possibly can before the end of the program, or at least get back with answers and in some form of format back to everybody, possibly in an email or some kind of alert that we might send out in response. So we appreciate everybody joining us today. Obviously, we've had one prior session, and we kind of wanted to do a second session based upon what additional information we have and where we are going forward with hopefully partnering with every one of you and all of our clients, dealing with what you need to do and what you need to know, and how all of this is going to work going forward. So if we move ahead here, obviously, let's state some things that are pretty obvious. First, the executive order that President Trump signed revoked the Executive Order 11246, which was the executive order which was establishing affirmative action plans for minorities and females that went back to the Lyndon Johnson era of 1965. Now, understand legally, a presidential executive order does not, withstand the weight of all law. In other words, Congress can override things by passing a law, which overturns any executive order. And as happened here, President Trump overturned an executive order from Lyndon Johnson. He's also overturned executive orders that Joe Biden passed and executive orders of other presidents. Likewise, people after Trump left office the first time, Biden overturned his executive order. So the fact that this particular executive order has been overturned for the moment doesn't mean that it's necessarily gone forever. So the first thing you need to understand is that executive orders are what they are. They're an executive decision by the executive in power at that time. That does not mean that things change or can't change, or that a new administration could change that in a heartbeat. So that's one thing to always keep in the back of your mind, because this could come back. depending upon who the next administration would be. But for the moment, what that means is that under this administration, affirmative action plans for minorities and females are no longer needed. They're not required under law. However, the president made it very clear that the law of the land is still anti-discrimination. And we all know what the law of the land is, and that's basically Title VII of the Civil Rights Act of 1964 when it comes to minorities and females. That law has been in existence for a long time. There's a large body of law dealing with what is considered to be non-discrimination or anti-discrimination. What is considered to be discrimination? Under Title VII, it prohibits any kind of discrimination based upon race, color, religion, sex, national origin, and as the Supreme Court has said, sex includes gender identity and transgender status. All of those groups are all protected under Title VII of the Civil Rights Act. So if a company is deemed to have violated that particular law, there are different ways that can be handled. Obviously, a charge of discrimination can be filed with the Equal Employment Opportunity Commission. That's the agency that oversights Title VII, just like the OFCCP out of the Department of Labor was established at some point to create and oversight Executive Order 11246, as well as two other laws which are not impacted by this, and that is the Vietnam Era Veterans Readjustment Assistance Act of 1974 and the Rehabilitation Act of 1973. Both of those two laws, as we'll discuss later, still have affirmative action plan components. So if you recall, when we do your affirmative action plans and have historically done them, there are three plans. There is a plan for under the Veterans Act, there is a plan under the Rehabilitation Act, and then there was a plan under Executive Order 11246. Two of those three plans still stay in effect. So you still have an annual obligation to create an affirmative action plan for those particular two laws, the Veterans Act and the Rehabilitation Act, along with reporting obligations, recruitment obligations, and tracking. All of that still stays in effect. Just because the president issued 173, he cannot change what the law currently exists. The only way that can ultimately happen is either through congressional action, which is unlikely to happen, or through some form of rulemaking to change regulatory actions. Well, that, as we all know, rulemaking under the federal level takes time because you have to create a new rule, you have to post it, you have to give opportunity for comments. There's the Administrative Procedures Act that actually has to be followed before all of that happens. And then, of course, any rule changes are always subject to a legal challenge. So any significant moves along those lines to attempt to try to change those kinds of things will most likely be met with any kind of with fight on the other side, and it's likely to be to end up in a court battle. So, what we currently have right now is likely to be and to remain in effect at least for quite some period of time when it comes to those other two laws. As for minorities and females, as I stated, Title VII is really the key player here because now the president has made it clear that the EEOC is charged with enforcement of Title VII and is to vigorously enforce them. So when I say on the second bullet here, the Title VII of the Civil Rights Act of 1964 is enhanced, it's not enhanced because of any change in the law, but it's enhanced by the president's own statements and the statements of the head commissioner of the EEOC, the chair, who has basically said, we intend to enforce this law in a strong way to make sure that all individuals are being treated equally and fairly under the law. So what does that mean for you? Well, that means, number one, that Title VII, which applies to all of these various kinds of practices that are listed here, from your hiring decisions, your promotion decisions, transfer decisions, any kind of compensation that you pay individuals, and your termination decisions are all subject to enhanced scrutiny by the EEOC to make sure that you are acting in a non-discriminatory fashion when it comes to this. And that can be on both an individualized basis as well as on a class basis. You know, when you look at what occurred quite frequently under Executive Order 11246, they spend a lot of time not only just looking at individuals, but also at groups of people. Are your groups meeting the requirements? If they're not, if they went in and they found a violation, they would be looking at back pay liability potentially for a group of people. Title VII under the EEOC can do the same. I've been involved in multiple nationwide, even class actions, where they would bring actions against individual companies alleging that their promotion practices were not being handled in a non-discriminatory fashion, and would challenge the hiring decisions and the selection decisions that were being made. And they would use statistics to attempt to establish that that was not being done properly. They would compare the selection decisions of whites versus blacks, of males versus females, of various groups versus other groups. And they would use that to attempt to establish that there was, in fact, a class of individuals who are being mistreated. So in reality, what the EEOC can do is very similar in that regard to what an audit might look like when it comes to those elements under Executive Order 11246, what the OFCCP used to do. So if we move on to slides, as you can see, Title VII in compliance, discriminatory actions always can be unintentional. I mean, you don't have to prove that I intended to make a decision that I was going to hire this white person. I was going to hire this black person. I was going to hire this other person. It can be done in a manner, like I said, where statistically all of a sudden you appear as though you have treated one group differently than another, or that you have treated an individual different than another because you have hired or selected other people, for example, who appear to be similar to this individual, yet you didn't select this person. And this person says, well, I'm black, and you hired whites, so I'm not being treated the same as others. So again, it doesn't have to be an intentional decision that has to be proven under Title VII. Always, and this applied regardless whether we were looking at Executive Order 11246 or we look at Title VII compliance, documentation is critical in all of these cases in order to be able to defend them. So when the EEOC does an investigation, they're going to be looking to see what documentation that you have to establish that the actions that you took were deemed to be non-discriminatory and in compliance with Title VII. No different than what the OFCCP would do when it was looking at in an audit looking at your selection decisions and deciding, is there any evidence there that you are not making your decisions in a non-discriminatory fashion. Um, Now, under the OFCCP, they required establishing, quote, goals. Now, even under OFCCP's laws throughout the period of time, understand there was a distinction between a goal and a quota. Quotas were never illegal. Quotas are not they were always considered to be illegal. You couldn't just say, well, I am underutilized in a group and my statistics show me that I should be somewhere like 20% in this certain professionals group, and I'm only at 5%. And it's showing statistically I'm underrepresented. Um, so your goal was to hope to try to get to 20%. But that did not mean that every hiring decision that you made was I've got to hire I've got to hire people that were underrepresented. That's a quota, and that's not what the law said. The law said you hire the most qualified individual available. That's a merit-based concept. Merit-based concepts existed under the OFCCP just like they did under and do under Title VII, and what this administration is pushing, merit-based decisions. If you have merit-based decisions that are made and are appropriate, then you hire the most qualified person. And that's what you have to have is that documentation to establish that's what we did. Yes, we see that we're maybe underutilized in an area, but we are making appropriate decisions so that we are selecting the most qualified candidate. That's what protects you. If you, on the other hand, did not make those decisions that way, but said, well, we're underutilized and we're going to hire, or let's say we're underutilized in Asians and we're going to hire an Asian. Well, that's not, we don't care who's the most qualified, this person isn't, then that doesn't comport with the law, either under Executive Order 11246 when it existed, or under Title VII for sure. So what I'm trying to show for you is there's a lot of parallels here, even though OFCCP's enforcement of minority and female anti-discrimination and affirmative action is gone. Title VII is not. It still has all of those same components in it. The only thing it doesn't have is that there's no goals we're talking about here. But what we are talking about is looking to see, are there areas where we may be underutilized? And if we are, we still want to make sure we hire the most qualified person. But by looking at that statistic, we know that if there was ever a class claim that, okay, I'm not hiring people in this area and I don't have documentation to prove that why I'm selecting a person not in that group, then I could be in trouble from a class claim standpoint. So you want to be able to know where are my issues. And then once I know where my issues are, do I have my documentation in place going forward in all of the decisions that are being made to be able to prove that the actions I'm taking are based upon merit-based. I'm selecting the person that's the most qualified individual, whether it's for a hire, a promotion, a transfer, that I am paying people on the basis of merit, that I am I'm terminating people on the basis of their lack of performance or conduct. So those kinds of things all fall within the same gamut. So if we move to the next slide, this is kind of statistical analysis and employment practices. I've kind of talked about this. Merit-based and defensible. So what we want to be able to do for you is to be able to provide you with the statistical analysis using the data that you have done before and provided to us, but it's going to be tweaked so it's going to look somewhat different, and we'll show you kind of what we're talking about here in a few slides. But it's going to be merit-based and defensible so that you can then be able to make those decisions that you need to make as you move forward, and then be able to document your decisions in a defensible fashion so that if the EEOC in an investigation of a charge comes and starts asking for data and asking for information, you will be able to defend those kinds of claims. Okay, so that's really important from that perspective. So it's important for you to know, do I have any issues? Where are my issues that exist right now in any group, whether minority or female, male, white, any group? Because now all groups are potentially out there to make sure, is there any problems in any group, in any of the groups that are appropriate? And we're going to talk about what is an appropriate group to be analyzed as we go forward here as well. So that regular review of your data to identify any statistical disparities becomes an important tool in your overall process of having a merit-based system. And that's what the government is looking for. Are you engaged in a merit-based decision-making process? Can you identify that that is in fact the case? And can we be sure that those actions are merit-based so that if any claim of individual discrimination or class discrimination arises, we can defend those decisions? And that's where the documentation becomes critical as we move forward. So moving forward again, just from a practical standpoint, just so that everybody is well aware, as you all probably know, and those of you that have been in HR for a long time, you know there's the Uniform Guideline for Employee Selection Procedures that has been in existence since the 70s. It's still incorporated under Title VII. It's still a part of it. That means that requires that you be able to collect the kind of data that we were talking about, that it's there, that you are following that data collection process in gathering your information about whether we are maintaining non-discriminatory practices when it comes to the areas of hiring and selection and promotions and transfers and the other issues that we talked about there. So compliance with all of these things has not really changed despite the Executive Order 1473 elimination of 11246. All of the things that 11246 still required you to do, with the exception of goals and the creation of a plan with some language about affirmative action and DEI kinds of comments. If you put that to the side, the guts of it, when the government came to audit you, they're not looking to necessarily, on most instances, to see, oh, how is your language, or how is this, or how is that. They're looking to see, what do the numbers look like? Where are the numbers, and where are you? And what have you done, and what haven't you done? And show us your documentation. Title VII does the same thing. In every claim I've had to deal with over the years, under Title VII, and particularly in class claims, we've always had to show them numbers. We've always had to show them the documentation. Same thing that you would have had to do under audits from the government, under OFCCP. So there's no real adjustments there. Okay, moving forward again. Again, understanding timelines, again, as we've kind of talked about this, 1473 was issued in January. Obviously, you can still maintain, and there was no problem with continuing to have affirmative action plans, basically up until around the end of April. The president has asked basically all of his agencies, including this one, to submit recommendations on changes within their agency by close to the end of May. Now, just because they're submitted doesn't mean that they're going to immediately be implemented. Again, Changes could be to regulatory issues, kind of like what we talked about before. Well, they've got to come up with redrafts of regulations. They've got to go through the Administrative Procedures Act. They have to do a lot of things. Internally, they could do some guidance within an organization. They could talk to the various field agents and the field offices about how they're going to go about doing certain things or what they're going to prioritize. Those kinds of things can all be discussed and implemented more quickly. But again, reality is that it's not going to be an immediate process. There's just no way they can do anything along those lines that's going to be beyond what it is. Plus, regardless of anything else, everything that we've been talking about thus far still is going to be in play no matter what. Because it's very clear again that they put the ball in the court of the EEOC to implement Title VII in a non-discriminatory, merit-based fashion throughout the process, and they're going to be enforcing those kinds of things. And so that's kind of what they're going to be looking for. Are we enforcing it in that fashion? Not from a quota setting process, which was never legal anyhow, but not from that concept, not from setting out a goal, but from what does our actual statistics look like and where are we really going to go with this? So that's kind of the process that we're talking about here. Now, as we move forward here to our next slide, basically what we're looking at from our perspective, from a Lighthouse perspective, to assist you in this overall process of making sure you are compliant with a merit-based operational system that still meets the requirements and from a statistical standpoint is going to be there and give you the guidance that you need going forward when we're talking about minorities and females. Is we're switching away from this goal attainment concept that was under existence to more benchmarks. This is kind of where you are. This is where you should be looking at. And this is if a government agency came in and was challenging a question, if the EEOC came in and was challenging we're back. Thanks, Lauren. And we are looking to try to challenge, let's say, a group of accountants that you may have had there, and they're saying that you are statistically underutilized in accountants for females. Okay, well, what kinds of here's where you look like. This is where you know. So as you make moves within that realm, can we defend each decision as we move forward? What decisions do we need to make? Because you now know, okay, this could be an area of concern if somebody filed a claim. The EEOC would see this because they would ask for the statistics. They would look at them, and we know we need to be able to be prepared to defend ourselves in some of these areas. And so that's what we want to do, is provide you with these benchmark areas so that you know where those things exist. So that way you can, you can make sure then going forward that decision making within those areas is going to be non-discriminatory. Okay, so all of this leads to what are our recommended best practices going forward, and how we would recommend working with you in conjunction, using your data to be able to put together the kinds of information you're going to need so that you can defend against any EEOC claims when it relates to race and gender. Hey, Greta, you want to pick up with a little bit here and then I'll fill in?
Yep, sure. So just like how we ran your affirmative action plan for females and minorities, we're going to run it with the same data that you've always provided us from the import template that you send us. But this time, and we're going to show you what it's going to look like on the next slide, but we're going to actually break it down a little more granular. We're going to look at each EEO code and then take it down further, which Bruce will explain. Then we're going to break it out by race, by every race and gender. So we'll see exactly where we have any issues, if we have any bias towards a group of individuals. Um, and then just like we've always done our applicant tracking, we need to keep dispositioning candidates. We still need to ask the race and gender question. Everything that you've done currently, we still have to do. None of that has changed. Because we also want to, besides the report, the first report for every race and gender, what we're calling a merit-based opportunity profile. We also want to run IRA's impact ratio analysis on your applicant slash hire logs, promotions, which I know a lot of you guys don't have true promotions. You know, a true promotion is not time and grade. It is a competitive promotion. And typically in audits, we don't see a lot of those, but we're going to run those statistics also on your termination log to see if we have any issues in our terminations as well. That's one of the things that we can defend against because we're going to have the numbers. Or if we have issues, we know we have some work to do. Just like when we review your affirmative action plan, we will point out any issues that we see and what we think we need to do to correct those. So if you can go to the next slide, Lauren. Now, this is the actual merit-based opportunity workforce profile. And this is what it is essentially going to look like. And we're ready to roll with this at this juncture. So anybody that has an affirmative action plan date after May the 1st, this is what your new report is going to look like. This was going to replace your placement goals or underutilization page. So I'm going to let Bruce explain the concept behind this and how the numbers work.
So if we were protecting you against any kind of EEOC charge claim, where individuals are alleging that they're disproportionately being denied opportunities in a certain area. The one factor we always want to look at first is the job title. So under your old affirmative action plans, as you know, we ran off of EEO1 reports, and there were the various job groups that existed under EEO1s, and some of you had more detailed ones, some of you had less detailed and just used the EEO1 categories. Here, we want to break it down into a more detailed analysis because any defense that would be raised in these claims is going to be based upon either individual jobs or upon groups of jobs that have the same knowledge, skills, and abilities. So that if you were moving people within these jobs, they all would be basically the same or would have the same kind of KSAs that exist. And therefore, that group would then be considered individually from that standpoint, at least from the EEOC standpoint. Now, the EEOC could also attempt to round these up into bigger numbers, but we would want to look at them for your perspective into a group. So let's say in the example here, you have accountants. Well, you could have 5 or 6 different kind of accounting jobs, but all of them have the basic background that you need to be an accountant as the basic KSA for that particular job. And so those may be round up there, but also we would be able to subdivide this into the specific jobs themselves. So if we wanted to look at a deeper dive, where is our concern? Where is our issue with regard to this? We could then look down and see, okay, where are we having the problem? Where does the problem exist? And from a more detailed perspective. Same as you can see, like there's engineering techs. Well, in the past, that may have been wrapped up with a bunch of other jobs, just like accountants could have been wrapped up with physicians and lawyers and other kinds of professionals. Now we're looking at it from a perspective of defending against merit-based decisions based upon jobs, so that we could defend it in front of the EEOC and in court. So that's what you're trying to do here. And so we've established a merit-based opportunity program based upon what the government has said they're looking for. So we want to provide that information to you so you can then look at this and see, okay, this is this is where we have some underutilization. You can see on this sheet anything that is marked with the little asterisk and is highlighted are classes that statistically are showing some underutilization. So, for example, in the accountant's realm, you'll see that there is some statistical underutilization on these numbers for the 50 accountants that exist in this particular company um, for females. And as you can see, it runs across for different groups. This allows you then to be able to say, okay, this is where we need to go. So when we do our initial plan breakout with you, we'll want to make sure we're not just looking at, we're getting our job title groups together correctly. So we would spend some time with you making sure we're providing you back the information on which jobs have the same KSAs that exist so that they can be grouped up if necessary. If there are none, then it would just be that particular job title and those people that are in there. So again, that would allow you to be able to analyze all of this and sort of see where your issues are, if there are any, and then okay, what documentation do we have in the past 2 years, which is what the EEOC is going to initially look at, is the past 2 years in particular. What decisions have been made, and can we defend those on any selections that have been made for people into let's say, an accountant position that are female, versus, what are we going to do going forward too? So we know we've got some issues in accountants. We need to make sure that as we're making decisions on future positions, that we are looking at that and looking at it completely to make sure that those decisions are made properly, and that we have merit-based documentation to support that, because the government's going to be asking for that. So this will be providing you with a significant tool to allow you to be able to know where your issues are and to be able to then start defending where those concerns could possibly be going forward. Because again, like I said, in my experience with the EEOC, they will look for the statistical information to be able to do their own analysis. EEOC have their own in-house economists and labor statisticians that do the statistics and run the numbers. So, they do quite a bit what OFCCP would used to do, the same kind of thing. So again, we have to do it. We're just looking at it from a different perspective, not just based upon groups of a variety of professionals, but we're going to break it into more strict KSAs, which can be broken down into subgroups of sub jobs that all fill into that group. So that's what that would look like. Okay, so it's important, if we move to the next slide, that you be able to continue collecting and submitting that data so we can then create this information for you going forward. Okay.
Yeah. And remember, I get this question at least once a week. Yes, like I said before, in our application process, we still have to collect race and gender and BEVRA and the IWD questionnaire. None of that has changed. So it's important that you don't throw all that out. We still have to collect all of that information. And then we still have obligations under BEVRA in Section 503, which is individuals with a disability. The executive order did not eliminate either of those two things. So when you and we can still say the word affirmative action plan for veterans and individuals with a disability. So the report that Bruce and I were just showing you, you will get that report along with your narrative portion for veterans and IWDs, along with your utilization, as you always have, for individuals with a disability. Now, granted, those things could change, but that's going to, as Bruce said earlier, that's going to take time if they
Or
want to make any changes to that. So right now, it is still business as usual. It's just a little, it's just going to look that one part a little differently.
yeah, so from a practical standpoint, what you're going to get is you're going to get the affirmative action plans, the information for veterans and for those with a disability, just like you have before. And then you're going to get these individualized merit-based opportunity workforce profile that we're looking at, which will give you the information you need to determine, are we having any issues where if the government challenges us or questions us in a charge or in an investigation as to whether we have made merit-based decisions, we know where our weak points are. If the government is looking at that, and we can then go back and we can prove that yes, we made decisions, and even if we are underutilized somewhere statistically, there are good reasons why, because the people we selected were the best qualified candidates. And that's what the government wants to see, is that we're hiring the people that are the best qualified candidates. But you're not going to know that unless you know where your underutilization exists. And so that's how that report will be a big advantage to you. And it will be broken out, like I said, in a more detailed fashion than what you've ever seen before. So it provides you with the data necessary to be able to defend those actions should the government question that going forward. The next thing on the recommended best practices is in the next slide, is the DEI program reverse. Now, obviously, the current government position is diversity, equity, and inclusion are bad programs. And, what we are, but that's not all companies believe that. And, but we do know that from a practical standpoint, it's probably appropriate for you to look at what your programs are called and make sure that they're not using that terminology in your programs. Making sure that you don't have any kinds of programs, and this is outside the scope of what we're talking about here. It's just any DEI type of program that you may have within your organization, that you may have had in the past for any number of opportunities, to make sure that you don't have basically a quota system where you have to have a certain number of this, that, or the other. That you need to look at to make sure that if the government ever came in, they could ask to see what kind of programs that you may have out there that would in any way be considered to be violative of the president's executive order when it comes to DEI. So you want to make sure that's in alignment. And then most importantly, after all of this, is to make sure you do some appropriate training. All of your HR staff and your managers need to be clearly in the loop in terms of what the requirements are under Title VII, as well as their continuing obligations under VEVRA and Section 503. But they need to understand with their decisions, the decisions that are made within the organization, whether they be compensation, whether they be selection, whether they be hiring, promotions, terminations, are all done within the confines of what Title VII will allow and where they're looking to go, which is, can we defend each and every decision? And we're going to be looking at it from both a statistical standpoint as well as the non-statistical analysis of your employment decisions. And when I say non-statistical, that's your data. What specifically do I have to prove that the person that I hired or the person that I selected for the job that's being paid differently than some other job, or I have distinctions within a job, that I can defend those decisions individually as well as a class. So it's important for managers and human resources to understand again how Title VII impacts all of this and what their obligations are when it comes to some of these decisions. The importance of HR when it comes to all of this, and that they follow up on all of these decisions, and that they have a role in oversight of all of this, because ultimately it's going to come down to, what decisions have been made, can we defend those decisions, making sure the actions are being taken appropriately. Managers need to understand that this is part of their job, and they need to understand that as part of their job, they need to understand the obligations. And then, of course, as part of all of this is the maintenance of accurate documentation of those employment decisions. So once you see, for example, in the example we gave earlier of accountants, and all of a sudden you have 3 openings for accountants, what documentation do I have, either from applications, from internal movements, which are going to be able to show that we are making a merit-based decision here, and we are hiring or selecting or promoting the most qualified person for the job. And will that be there? Um, can I make that kind of distinction? So that's that's going to be critical. That's going to be critical. Okay, so I know we've kind of run over a couple minutes, so I'm just going to kind of try to wrap this up with Greta. Um, from a conclusion, basically, we know that things will be evolving, but from our perspective, it's very clear that compliance with Title VII is going to be really critical. And compliance with Title VII means analysis of the data, still like we were doing before, because that's critical. Maintaining information on race and gender, doing the kind of workforce-based analysis so that you can look at it from a merit-based opportunity standpoint, and then making sure that your policies are aligned with the concept of non-discrimination towards all, whether you're a white male or you are a Asian female. It doesn't matter. Everybody has to be treated equally from that perspective. So our goal is to work as your partner to continue to provide you with this information, to do your affirmative action plans where required under VEVRA and the Rehabilitation Act, and to provide you with these merit-based opportunity workforce profiles for your race and gender individuals. So gathering the same kind of data, providing you with that information. Like I said at the beginning, we're going to be working with you closely on how we're going to group these jobs now, or individual jobs as the case may be able to roll them down and roll them back up so that you can really look in detail at your workforce and be prepared to then, as you go forward during the course of the year, okay, this is where we know we need to be focused on during this period of time.
Yeah, and let's don't forget that in the executive order, it does state that federal contractors are going to have to certify that we don't discriminate, that it is merit-based. The only way we can truly say that with any certainty is to actually run the statistics that we've been talking about today. That's why we feel it's really important that we do these moving forward.
Yeah, if you do nothing and you don't run analysis, you say, well, I don't have to do anything, then you are opening yourself up to potential major liability down the road because you haven't done anything. You're not paying attention at that point in time to what you're doing. You don't know if you really have any potential claims that could be potential class claims that exist out there right now. And then you're not being prepared to focus in when decisions need to be made in those areas. Do we really have all the appropriate documentation we're going to need? if somebody just makes a claim that, no, you didn't select the right person, and all of a sudden you have the government coming in and looking at all of that. That's why it's critical to just say, well, this is gone and I don't have to worry about it anymore. You don't have to worry about goals anymore. That's true. That part is absolutely true. You don't have to worry about some language stuff. But what you do have to worry about is compliance with Title VII, which is picking up exactly where the OFCCP left off when it comes to analysis of statistics. And so that's where these new reports will be beneficial to you in compliance.
So I think I've answered everyone's question that had one in the Q&A. If I didn't, please reach out to me. And sorry we went a little over, guys, on probably a lot of your lunch hours. But if you think of any questions after this, please don't hesitate to reach out to me and or Bruce, and we'll get the answers to you. And as things keep evolving and changing, we'll try to do some more of these webinars and put out more alerts. And we will be sending out links to this recording, hopefully later this afternoon, if not first thing in the morning. I hope you guys found that information useful today. But like I said, if you have any questions, please don't hesitate to reach back out.
Yeah, and be sure to, as I said, if you've got data coming up or the data in the rest of the year, make sure you submit it, and we will have those plans ready for you on VEVRA and the Rehab Act, as well as be preparing these merit-based opportunity workforce profiles. Thank you.
Thanks, guys. Talk to you soon. Bye-bye.